Hello, everyone, and welcome to the OKT podcast. My name is Krista Nerland. I'm a lawyer at OKT, which is a law firm that specializes in Aboriginal law and supporting Indigenous jurisdiction. We have offices in Toronto and Yellowknife. With me today are my colleagues Judith Rae and Jessie Abell. Judith, can you tell us about yourself?
Hello, everyone. My voice is a bit scratchy today. My name's Judith Rae. I've been working at OKT since 2008, and I work primarily in areas to do with services, such as child and family services, education, justice, health, and so on.
Jessie, tell us about your practice.
Hi, everyone. So my name is Jessie Abell. I'm an associate at OKT, and my practice is primarily focused on litigation. So I do litigation around Aboriginal title and rights and treaty rights, and focusing on sort of advancing Indigenous self-determination.
Thanks, Jessie. And like Jessie, I'm a litigator at OKT, and my practice focuses on Aboriginal rights, treaty rights, Aboriginal title, the occasional judicial review, and some appeals like this case, which we're here to talk about today. So today we have come together to talk about a Supreme Court of Canada decision that came out last Friday. I'm going to call it today the C-92 reference. It was a decision from the Supreme Court of Canada about the constitutionality of an act respecting First Nations, Inuit, and Métis children, youth, and families, which is a bit of a mouthful. This is a decision that we've been waiting for a long time from the Supreme Court. The case was heard back in December of 2022, and so it's taken them about 14 months to come out with this, which is frankly like a lot longer than your sort of run-of-the-mill decision, and it has pretty significant implications for the First Nations across the country and other Indigenous nations across the country who are exercising their jurisdiction under the Act, using it as a tool, or who are interested in exploring ways to exercise their jurisdiction over child and family services. Today, we're going to do a couple things. We're going to start by talking about the Act, where it came from, how it operates. Then we're going to talk about why it was being challenged and what the Supreme Court had to say about the challenge. And then we're going to spend a bit of time talking through some of the implications for First Nations across the country. So to get us started, I'm hoping, Judith, you can tell us a little bit about how this act came to be and what it does.
Yeah. So it is a federal law that does something that was quite novel, quite unusual in some ways, and in many ways quite exciting. Just in terms of where it came from, I think it came ultimately from a very large and broad movement of Indigenous peoples who have been bringing forward the assertion of their own jurisdiction for many decades now. And at the same time, the movement around the child welfare system in particular, and concerns with that system and how it's been impacting First Nations children and other Indigenous children to an extent. So those have been big issues over the last decades, and that they've also really, especially in terms of the child welfare system and how it impacts First Nations children, that's really come to the fore in the last decade in a number of ways. One is with the Truth and Reconciliation Commission's report in 2015, which has to do with, of course, residential schools. But in talking about the impact of residential schools, the TRC chose to really forefront the issue of child and family services, child welfare, as we sometimes call it. And they put their calls to action about child and family services right at the front of their report, because they saw that as some of the most direct impacts flowing from the intergenerational trauma of residential schools. So that really put that conversation into the forefront. And one of their calls to action was for national legislation. So that's part of where it comes from. And since then, there's been a number of other pieces of the movement. I mean, First Nations have been pushing for recognition of their own jurisdiction for many years. And I think in the wake of the 2016 decision of the Canadian Human Rights Tribunal that found that Canada had been discriminating against First Nations in its funding of Child and Family Services, those calls for First Nation control and jurisdiction, became all the more prominent and a big part of the conversation about how that area was going to go forward. So we ended up with this federal act. Briefly, what does it do? It does two things. They're quite different. The first thing that it does is it sets some national standards about the practice of child and family services as applied to Indigenous children. There's about 10 sections of the law that relate to that. Those apply right away. They're in force right now. And they kind of layer on top of other jurisdictions that are more substantively setting out those services in a bigger way. Currently, that's primarily provincial and territorial jurisdiction. So they layer on top of that and add some pretty high level principles, largely to do with the prevention focus and things like cultural continuity. So that's the first part of it. The second part of it, which is much more interesting, much more exciting, and much more disruptive, frankly, is that the Act recognizes the inherent jurisdiction of Indigenous governments in this sector, child and family services. That's the wording it uses. And it sets out a bit of a pathway that, if used, an Indigenous government could make its own laws, and then the pathway there could kind of confirm ways for those laws to override the provincial and territorial laws that may be there now. I'll stop there.
Great. So, this is an important initiative to deal with the issue of overrepresentation of Indigenous children in the child welfare system, an issue which, I think it's really helpful to bring up the TRC report, because what the report does in a lot of ways is connect the assimilation drive that was at the heart of the residential school system to the operation of the child welfare system as it's happening today. The ways in which pulling Indigenous kids from their families and their communities is sort of continuing those effects into the present, not just repeating the intergenerational trauma, but actually continuing the policy of assimilation. And so, obviously an initiative to address this has been a pressing need for a really long time. So I guess I want to ask Jessie then, if this is something that's sort of really needed, why was Quebec, I think it was Quebec who challenged this act. So why did Quebec challenge the act?
Yeah, so as you note, it's Quebec that challenged the act. So Quebec brought a reference to the Quebec Court of Appeal. And a reference is essentially when the government asks the court for an opinion on a big legal issue. And so Quebec's question was about whether the act is ultra vires, or outside the jurisdiction of the Parliament of Canada under the Constitution. So just to zoom out for a moment, like under the Constitution, the federal government has certain areas it's able to legislate over, and the provincial government have other areas that they're able to legislate over. And Quebec argued that the whole act was outside of the federal parliament's jurisdiction because it intruded on provincial jurisdiction in the area of child welfare. So it sort of moved into the provincial areas. And Quebec also argued that it attempted to amend the Constitution without following the proper procedure, because Quebec said, because the act affirmed a Section 35 right to self-government, a right to, that the Indigenous peoples have a right to self-government over child and family services, and that's recognized in Section 35 of the Constitution, Quebec said that kind of affirmation in the act was actually an amendment of the Constitution and improper. And so that question went to the Quebec Court of Appeal, and then the Quebec Court of Appeal held that the act was constitutional, except for specific provisions. And these are the provisions that deal with conflicts and paramountcy. And the Quebec Court of Appeal said those specific provisions were an attempt to change the architecture of the Constitution, but otherwise the act as a whole, the court held, was valid. And a big part of the Quebec Court of Appeal decision, which was quite interesting, it rested on the idea that Indigenous peoples have an inherent right of self-government over child and family services, which is protected by Section 35. So it sort of held that affirmation in the act was correct, that there is such a Section 35 right. And this was quite a new development legally. So it was really interesting to see that focus in the Court of Appeals decision.
Yeah, just to pick up on what you're saying there, Jesse, this question about what Section 35 protects. So Section 35 of the Constitution Act is the provision that says the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. And Quebec's point was that because there hasn't been a court that has said yet, this right includes the right to legislate, to pass laws in relation to child and family services. Because no court has said that yet, Parliament can't say it, and Parliament can't act that way. It's the court's job, Quebec was saying, to tell us what Section 35 means, not Parliament's. And so that was the argument that they went in with. And the reason they were able to go in with that argument is because the court's jurisprudence on Section 35 so far, the cases that they've released, have really been focused more on things like harvesting rights and not these big questions of how Indigenous governments can pass laws and regulate their people and their territory. So, this act does something that the court's case law hasn't done yet. And Quebec said that's a concern. So let's talk about what the Supreme Court did with these arguments. Judith, do you want to tell us actually the sort of high-level outcome of the case?
Sure, happy to. The Supreme Court decided the case in a simple way, by saying, yes, the federal government can make this law. That's it, basically.
Yeah.
So, Quebec asked, can they do this? And the Supreme Court said, yes.
Yes.
That is the simple summary I'd give. In a way, it feels a lot more complicated because of what the prior decision, the Quebec Court of Appeal decision, had done, which was take it in a bit of a new direction by really exploring Section 35, which, to be fair to the Supreme Court, because now people are saying, oh, well, we wish they had explored that or whatever, but I do feel, that wasn't really the question that was asked. The question that was asked wasn't, do Indigenous governments have jurisdiction under Section 35, have this inherent jurisdiction in child and family services? And this was a dispute between the province of Quebec challenging a federal law, and they asked, did the federal government have the power to pass this federal law? And the Supreme Court said, plain and simple, the answer is yes. And, we really don't need to get into, and frankly shouldn't get into at this time, what Section 35 Indigenous rights may or may not exist. So I think it's, in a way, the decision is quite simple. It just upheld the federal government's power to do what it did.
It's a good point. And, when you say the question that the court had, the reason why Quebec got to define the question that the court was supposed to answer, because this case came to the court by way of a reference, which Jesse mentioned is when a government asks a court for its opinion on an important legal issue. So Quebec went to the court and said, we'd like your opinion on whether Parliament was within its jurisdiction to pass this act. And so the Supreme Court really focused its analysis on that answer, rather than getting into these kind of bigger, more fundamental questions about where Indigenous jurisdiction fits into the framework of what's now Canada, right? With its federal jurisdiction, its provincial jurisdiction, and we would argue its Indigenous jurisdictions also.
Yeah, and if I could just briefly comment, I mean, the way I've always thought of this legislation is it's about recognition, right? It's about the federal government saying, we see your jurisdiction, we recognize it, And in addition to that, it offers this very practical tool to say, we see your jurisdiction, we see that it's inherent. And if you do these things, then we will guarantee, using our federal power, that your Indigenous laws will override. And that provides a very neat kind of clarity. That's very practical, frankly. It does skirt the bigger issues of, could a court type of test for Section 35 rights be made out? And what is that test? Are we using the old version of the test? Or are we going to say something new? The federal law itself, C-92, it just kind of gets around that by saying, we see your jurisdiction, we recognize it. If you want to do A and B, we will use our guarantee to ensure your laws can override. And that lets people move along in a certain way. And I guess that's what the Supreme Court has said. Yeah, go ahead. You know what I mean? If you want to go ahead on that way, go right ahead. It does skirt these bigger issues of kind of court recognition of inherent rights and stuff. But on a practical level, people are able to move ahead with their inherent jurisdiction using that recognition.
It's such a good point, Judith, and I think there's a couple things in the decision that really reflect on this. So one part is where the Supreme Court is talking about how expensive it is to litigate Section 35 rights and how long it takes. And then sort of paired with that, how long negotiations can take and how expensive those can be. And in the face of that, the court sort of said, okay, like looking at this situation, it's a very, as you say, practical way to move forward. And if it facilitates the exercise of jurisdiction on the ground, then that's in some ways as important or more important, you might say, than the sort of more theoretical questions behind it. That's one way of looking at it anyway.
And something to note too, like as we've been speaking about, this is a reference. And so Quebec brought the reference and then the responding party was Canada. So the two parties that are arguing about this are two crown governments. And so Indigenous groups and Indigenous communities intervened on the issue and sort of have, when you intervene before the Supreme Court, you have about 5 minutes to make oral submissions for the most part. So submissions are quite limited. And so this ended up being a case between two crown governments. And whether that was the right space to be debating whether Section 35 contains and protects a right to self-government, perhaps that question is better left when different parties are at the table.
So let's turn to some of the implications of the decision now. I think a lot of us were hoping or expecting that the Section 35 aspect of it would be dealt with more substantively. It wasn't. But there was something in the decision that we kind of didn't have on our agenda, or that we weren't expecting to see necessarily out of the Supreme Court at this time. And that's how it treated the United Nations Declaration on the Rights of Indigenous Peoples. The status, we'll call it UNDRIP. The status of UNDRIP has been, I would describe it as an unsettled issue in Canadian law for a long time. And different courts have kind of approached what to do with it in a different way. So UNDRIP is an international declaration, not a treaty. Canada has signed on to it without qualification. But at least in a sort of technical legal sense, it's not like, for example, the Convention on the Rights of the Child, which is a binding international treaty. It's more a statement of the rights that exist at law. And courts have kind of gone back and forth about what to do with Canada's acceptance of it, what to do with the legislation that implements it federally and in some of the provinces. And here the court came out with kind of a strong, but at the same time off-the-cuff statement about how we should think about UNDRIP in Canadian law. So, Jesse, you want to tell us a little bit about that part of the decision?
Yeah, definitely. So yeah, as you noted, I think the Supreme Court up until now has sort of skirted the question of the sort of the status of UNDRIP in Canadian law. They've sort of talked about it as an interpretive tool, but haven't weighed in on it significantly. So a really interesting component of the decision is that for the first time, the Supreme Court talked about how the federal act, the United Nations Declaration on the Rights of Indigenous Peoples Act, which is federal legislation that affirms the implementation of UNDRIP into Canadian law, the Supreme Court said that Canada has implemented UNDRIP into Canada's domestic positive law through this act. So as you note, it's a bit of a bare statement. So the court talked about how it's been implemented into Canadian law, into statutory law. They sort of, I think there's some questions that emerge out of that. And it sort of remains to be seen, for instance, the nature of which, the extent to which that's binding on the provincial crowns. Like, I think there's some questions about the extent to which it's binding on the crowns, but it's certainly a step forward and kind of a step further than the court has gone before now.
This idea of domestic positive law, it's to say, so what the court actually says is UNDRIP is part of Canada's domestic positive law. That's a phrase, domestic positive law, that I'm not, like, as a lawyer, familiar with in my day-to-day work, And I think it's a little bit like ambiguous what it means. What do you, Judith, Jesse, maybe one of you wants to take a stab at when we say UNDRIP is part of Canada's domestic law? Like, what does that even mean?
I think it just means it has enforceability as a law of Canada, as opposed to just being an international law or part of the international, legal framework. And, there's a long history of decisions around how international laws can be considered in Canadian law in an enforceable way. I think what we're seeing here is exciting because it is really a move towards, I'll say, at least greater enforceability of UNDRIP in Canada. There may be some factors in this case that are a little bit unusual because UNDRIP was specifically referenced in C-92, the law about child welfare. That is the subject of the decision. And, a connection there is very explicit in C-92 by saying we are trying to help implement UNDRIP through this law. But I think certainly what's in the Supreme Court's decision about it is to say, yeah, in passing the UNDRIP Act, the government of Canada has taken certain steps. And, they've taken very, direct steps about UNDRIP, and they're making it, they have now made it part of Canadian law. And so I think that can have implications in a number of other sectors, because obviously UNDRIP is very broad, has a number of rights. It talks about a number of things, from self-determination through to lands and resources, through to administration of justice, and, all kinds of topics are covered in some way by UNDRIP. So it is, I think, exciting to see that interpretation of the UNDRIP Act in a way in this decision, though, I guess the caveat I'm saying is that this wasn't a case specifically about the UNDRIP Act, and there is this, potentially greater link to the C-92 Act because it mentions UNDRIP. But I do think it is exciting. I think we're seeing something positive and new in terms of an embrace of UNDRIP in Canadian law through this decision.
And to your point, Judith, too, yeah, I think your point about what's so exciting about this is that UNDRIP enshrines so many rights from, the right to self-determination, the right to autonomy or self-government in matters relating to sort of internal affairs. It enshrines a lot of rights of Indigenous peoples that can have applicability, across a wide spectrum of things. It enshrines sort of a right to free, prior, and informed consent over decisions that might affect Indigenous peoples. So these rights are quite strong, and to be able to rely on those and see them implemented into Canadian law and enforced is, the prospect of that is really exciting.
Yeah, I mean, as a practical implication, I would say, I think a lot of lawyers, I would say probably us included, are going to be turning more to UNDRIP more directly.
Yeah.
In both negotiation and litigation contexts, with the backing of this Supreme Court decision behind us. I can certainly imagine a lot of, lawyers and, and Indigenous clients behind them doing that.
Absolutely. I think, Judith, you mentioned the sort of explicitness of this act in relation to UNDRIP. So this act is an effort, Parliament says, to implement UNDRIP. And that's, one part of what the UNDRIP Act commits Canada to is bringing its existing laws into compliance with UNDRIP. So in that sense, there's a strong connection to this law because this law is trying to bring child welfare law into compliance with UNDRIP. But the question, this other statement that the court made, which is that UNDRIP as a whole is part of Canada's statutory law by virtue of the UNDRIP Act, that's kind of a bigger statement and a bit of a different statement, right? That's saying these rights in UNDRIP are part of the statutes of the federal government now, potentially, or should be treated as such. And there's a lot of potential to explore there. The decision deals with the issue pretty quickly, considering its import. But I think you're right that we're going to see a lot of First Nations and their lawyers really pushing this issue in negotiations and pushing this issue in court because there's a lot of opportunity there to advance pretty meaningful rights.
Yeah, and I think, look, Indigenous peoples have, created UNDRIP and have been using UNDRIP in a number of contexts since, but I think it doesn't, with mixed results in terms of traction. But I think we are seeing a bit of a snowball maybe with UNDRIP, now that the UNDRIP Act is there federally. And as you said, there's some, provincial and territorial equivalents or, types of legislation around UNDRIP. I think with that, and now with this decision, I think there's a lot more ammunition, if you will, a lot more weight behind the use of UNDRIP. So it's one thing to just say, well, UNDRIP supports this. And I think a few years ago, people eyes may have kind of glazed over and people might have said, yeah, but that's a bit harder to get away with now. There's just a lot more weight behind it. And obviously there is a lot there to work with. There's a lot of very powerful, high principled statements in UNDRIP that I think a lot of Indigenous peoples can get behind. And obviously, like I said, it was drafted, internationally by both state and Indigenous peoples. So it's I think, an exciting moment for UNDRIP in Canadian law, and I'm excited to see where that piece goes.
And to your point, Judith, too, about like components of the decision that have held or that have talked about the government's responsibility and sort of the enforceability. There was a lot of there was a lot of exciting stuff in the decision about how the federal crown is sort of bound by some of these affirmations in the Act. And I wonder if, Krista, you could speak a little bit about the way the decision talked about the federal crown's responsibilities and the federal government's responsibilities in relation to Parliament's affirmation in the legislation.
Yeah, sure. So the Act makes this statement, which is that Indigenous peoples have an inherent right of self-government in the area of child and family services, and that inherent right, which just comes from their status as peoples, is protected by Section 35 of the Constitution. So that right is inherent and it's also constitutional. And the court said Parliament was absolutely free to make an affirmation like that about how it understands Indigenous peoples' inherent rights and their jurisdiction over children and families. And having made a statement like that in the law, and having also said in their law that they're going to be bound by the Act, Canada now has to act in a manner that's consistent with that statement that it made, that Indigenous peoples have this jurisdiction and that it's constitutional in nature. So that's important because it means that if you're sitting at a negotiating table with Canada, or if you're in a court proceeding with Canada, they really can't, the court says, be heard to say anymore, this jurisdiction doesn't exist, or this jurisdiction is not protected by Section 35. Canada now, as long as this Act is in force, has to act in a manner that's consistent with what it committed to in the legislation. And the court did something kind of interesting here. So there's this doctrine in Canadian law called the honor of the crown. And it's a pretty flexible doctrine, and it gives rise to different obligations in different circumstances. One of the sets of obligations that you see associated with the honor of the crown is to diligently implement treaty promises and to interpret treaty promises also in a generous way. Now, this idea of interpreting a commitment generously and then acting in a really diligent sort of, like working at making it real, that has been applied to treaty rights, and it's been applied to other kinds of constitutional promises. Here, we saw the court apply it to a statute, this C-92. Because Canada set out its statement about how it understands Indigenous peoples' jurisdiction and said it was going to be bound by that, now, the court said, Canada has to interpret that right generously and take sort of diligent steps to implement it. So that's a very powerful, positive obligation on the Crown to actually work in a serious way to make this right real. And for those of you who find yourself in the C-92 process and who are negotiating funding arrangements and who are negotiating coordination agreements, this is a space where Canada's obligation to act diligently to make your right real will have implications, could have funding implications. For example, how can you make a right real to exercise jurisdiction if the laws aren't properly funded? These kinds of arguments are really available at negotiating tables now, and that's quite an exciting development. And as I mentioned, it's also, I think, a nudge forward for the doctrine of the honor of the crown because it's applying it in some new ways to statutory promises, not just constitutional promises. So that's, I think, another important development of the decision. Now, I want to give a caveat on that. One of the places where the Act is, or the decision rather, where the decision is a bit unclear is the extent to which provinces are going to be bound to act in the same way the Crown is around this affirmation. So what the Supreme Court says is essentially that the operative provisions of this act, things like the federal standards, the conflict provisions, those are going to bind the province. But it's less clear, the court hedges a little bit, does this affirmation about the scope of Indigenous jurisdiction bind the provinces? Oh, they don't feel comfortable saying. And so they left this issue a bit unsettled. I mean, Judith, I don't know your perspective on this. That was my read of the decision. They were sending some conflicting signals and really trying not to answer it here.
Yeah, I do feel like there were a bit of conflicting signals around the impact of this law on provinces. Some parts are clear. So, they were clear, to me it was clear anyway, in the decision that, say, provinces have to comply with the minimum standards, right? Those have been set out. They said, Quebec had tried to argue, for example, these national standards, they impose on us, they interfere with our jurisdiction, whatever. And the court said, no, these are not a big deal. You can do it. It's an incidental impact on you is what they would call it, legally, to say that, yes, provinces have jurisdiction, that they can exercise in child welfare. The federal government has a jurisdiction in relation to Indigenous peoples. Those things can overlap, and the overlap is, not going to kill you, essentially. You just have to deal with it. You're going to have to actually implement those minimum standards, and you can do it. I think where it gets a bit unclear to me is in terms of the jurisdiction piece, what is the provincial legal duty? You know what I mean? Like, they were very clear that the federal government has now tied itself to the concept of Indigenous jurisdiction, and they seem to want to preserve a bit more space for provinces and territories around that in saying, well, you didn't make this legislation, so if you take a different position, in a court, for example, you could take a different position in a court. But it wasn't totally clear to me how far that goes. You know what I mean? Like, say, the Act, for example, they were quite clear that the Act does bind provinces and that they must comply with it. And I guess it just kind of remains to be seen, what does that actually mean? You know what I mean? Like, the Act doesn't say, well, then a province must take X position. So I think they, pull back from that. But, the questions that go to my mind, which are very active, frankly, are about the positions that different provinces are taking when Indigenous governments are exercising their jurisdiction and taking the steps that are outlined in the Act, say, to request negotiation of a coordination agreement. And, that request is important because without a coordination agreement, you're unlikely to have funding to implement your law. And, the Act, what it says is that an Indigenous government can request to negotiate an agreement. It doesn't actually require anybody to negotiate with you. I think it's safe to say that the federal government is now bound, I would say, to negotiate. It doesn't explicitly say that in the Supreme Court decision, but to me, that would be a necessary implication of what they're talking about. But we have seen provinces, most have agreed to negotiate by and large, but there has been at least one instance of a province refusing to negotiate. And of course, as provincial governments, the leadership of provincial governments come and go, we could see more of that. Or we might not. I think, to me, that's an open question is it open to provincial governments to say not negotiate or, refuse to recognize and implement, within the course of their exercise of jurisdiction, to recognize the Indigenous jurisdiction. That's essential because there's a reason they use the term coordination agreement. There's a lot of coordination that is necessarily involved in the implementation of any Indigenous law in child and family services. That is just a fact. Because on the margins of their population or their territory, however they design it, there's going to be people who are under provincial jurisdiction or operating in that way. And it requires coordination by provincial agencies and provincial courts to make this real. And the Supreme Court is sending a message, this is real. This is the law. The Indigenous laws prevail. That is a legal fact. So I think there isn't that much room to resist available to provinces, but I guess there's a little bit of space that the Supreme Court is leaving open, and it remains to be explored a bit.
Well, I'm excited to see where this question goes because, although the court expressly declined to address the Section 35 issue, I think it's fair to say that they sent some positive signals about how they see Indigenous jurisdiction in this area. There's some parts of the Act where they talk about or the decision, there's some parts of the decision where they talk about how essential to the cultures of Indigenous nations taking care of children and families is, and how they've never had to consider a case that's like a self-government case where something is that important to the culture of the First Nation. Now, our like current test for Section 35 comes from a case called Vanderpeet. And Vanderpeet, I think it's fair to say, has been subject to quite a lot of criticism. What Vanderpeet says is something is a Section 35 right if it is an aspect of a practice, culture, or tradition that was integral to the distinctive culture of the Indigenous nation before contact with Europeans. So there's a lot to unpack about why that's not great. And we've seen a few like really important lower court case laws criticizing that test recently. But what the court is signaling in this decision is if something has to be integral to the culture of a First Nation, if there's a self-government right that's integral to the culture of a nation, it's self-government over families and children. That's the one. They're saying that's really important. And they said something really interesting. They said, and you know what? Canada knows it. And you know how we know that they know it? We know that they know it because when they wanted to assimilate Indigenous people and dismantle Indigenous nations, what they did was residential schools. What they did was take children away from their families and communities. So they know that this is essential to the culture. So this part of the decision is a signal from the court, I think, that whichever way this test is going to go, whether we're going to stick with Vanderpeet in the future, whether we're going to move in a new direction, this area of jurisdiction is something that they're kind of interested in or open to as a Section 35 right, I would say. That's my reading of what they said here. What do you guys make of that? Do you agree, or do you think I'm being unduly optimistic?
I see what you're saying. I agree. I mean, put it that way. I agree. I think they sent some positive signals. I think, and they were clear about the fundamental importance. I noticed the part that you were describing there as well. I think it was very strong. I think where they wanted to keep their hands close to their chest is about whether they would change the test for Section 35 rights. I agree that the Vanderpeet test is very problematic, very poorly suited to self-government issues of all kinds. And what was really exciting about the Quebec Court of Appeal decision was its willingness to revisit that and do something different when it came to considering self-government. Yeah. I think the Supreme Court really did, I think, intentionally hold its cards quite close to its chest about that. It did not give a signal to say we're open to looking at a different test, which is not to say that they're not, but they definitely avoided saying that they were. But I think I agree with you in saying that in terms of this issue, they were kind of saying either way, whether it's the old test or a new test, because what they said is even under the old test, this seems like a good candidate. That's kind of the message that I was getting.
In the hearing, I think the judge's questions revealed some differences of opinion on this question. And my guess, based on reading how this part of the decision is worded, that there remain some differences of opinion among the justices of the court about how to and whether to adjust the Vanderpeet framework to make room for the kinds of rights that are really central to Indigenous nations as peoples, like lawmaking powers in various areas. And so rather than settle it, they sent some signals and kicked it down the road because they couldn't agree. And I think they wanted to do this all together.
I think that too, Krista. I agree. And, in waiting the long wait for this decision, I was worried that we were going to get a split decision and that people must not be, able to agree. And I thought, maybe we're going to end up with a decision that goes in a bunch of different areas. And, in my mind, I thought, well, I think we're the center will still probably land is in upholding the act on these more narrow grounds.
Mm-hmm.
And that's exactly what happened, but it wasn't a split. It was unanimous. And so I think we saw, in a way that's better. And in many ways, it's better, actually. But, it comes together in this really unanimous voice saying this is upheld 100%. And we all agree. But I think to all agree on that, I think there's no doubt that some differences of opinion were addressed by not speaking to certain things. And that's, I would really guess to be one of them.
Mm-hmm.
Go ahead, Jessie. Sorry.
Oh, I was just going to say, yeah, it's such a strong statement to see a unanimous decision out of the court, which I think has been, I haven't seen sort of a big decision at this level be unanimous in a while. So that's quite powerful. But also to your point about sort of prospects for revisiting Vanderpeet, obviously this was not before the court. But I think something in the back of our minds is that out of the Quebec Superior Court, there was this decision recently, RN Montour, in which the court explicitly modified the Vanderpeet test. And so it feels like that's the kind of case that is no doubt going to move upwards, probably up to the Supreme Court. And so there are these prospects for the court to consider this explicit question about, is it time to change the test? Again, obviously this wasn't before the Supreme Court in this decision, but there's sort of movements in the background.
Right, that Quebec Superior Court decision that you're referencing, it came out after the hearing in the C-92 reference. So there wasn't an opportunity, for example, for counsel to comment on it at the court or anything like that. This reminds me, the power of a unanimous decision. We've spoken around a little bit the conflict provisions in the Act, and that was the part that the Quebec Court of Appeal was like, this is too much for us. By allowing Indigenous laws to come on top of provincial laws, that's where you're modifying the architecture of the Constitution. And I think the Supreme Court made a very correct and justifiable decision that no, those are a perfectly proper exercise of Parliament's ability to incorporate things as federal law and to apply the general rule, which is that where there's a conflict between federal law and provincial law, federal law is the one that comes in on top. And they've taken that power and they've extended it to Indigenous law. So, Judith, I wonder if you could speak about the implications of this part of the decision.
Yeah. Well, that's the best part of C-92, in my opinion.
Yeah.
Is those conflict provisions. They're extremely useful because, this is an area where obviously the provinces and territories have laws. They have systems. They're out there. Those laws are being applied to Indigenous peoples, all over the country. And to do something different, you have to displace those laws. That has been the holdup in this area for many years. So, and to displace those laws, I think it's very helpful, especially in an area like Child and Family Services. I mean, in other areas too, but certainly in this area, it's helpful to do it with clarity and simplicity. Nobody wants to be dealing with a family, a vulnerable family in a state of crisis. And, then to start wondering, which laws do we think apply? Is there maybe a very complicated legal test that we can turn to and examine multiple factors to consider what might result in, 5 lawyers will give you 6 different opinions? That's not a great situation to do here. And I very much appreciate that the federal government put conflict provisions in its law and that they're very clear and very simple. And, that is the Indigenous law would prevail with these few exceptions. And that's very workable on the ground in a lot of ways. And we don't always get that in our area of law. You know what I mean? You can get that sometimes in an agreement. You're not getting that from courts. Courts have been much more fans of the complex multi-factored test.
Yeah, what we need here is an 18-part balancing test to resolve this issue. Yeah.
So, I think I'm very glad the court upheld those provisions. They're very practical and, they are an exercise of federal power in a sense, but that doesn't take away the inherent force of the Indigenous law from an Indigenous law perspective. The law, C-92 as a law has said, if you do A and B, then the Indigenous law also has the force of law as federal law. And, that also is important. I noticed it from the very start of looking at this legislation. I think it's significant because it recognizes that Indigenous laws do have inherent force, but that Canadian courts haven't had a full interpretation of what that is, or in all circumstances, or what have you. And that the federal government has decided in this circumstance, we're just going to be very clear. And we're going to say, if you do A and B, we're going to give your law the force of law. In addition, in addition to its own force, we're going to give it force as federal law, and we're going to confirm that it prevails. And I think that clarity of approach is very practical.
If there's someone listening to this who is in the process of working on their own Indigenous law or is considering, and they want their law to have to sort of also have this power to prevail over provincial law, what do they have to do?
Well, you have to create a conflict, which, I think anyone working on a law should be working with a lawyer with technical expertise to assist with the drafting. I think there's multiple ways to draft a law, and certainly, but I think some technical involvement of a lawyer in terms of the wording of things can be helpful. And it's important to create that conflict, either just what you'd say implicitly by creating other rules that, cannot really peaceably coexist with the provincial system in a sense, or explicitly, which means you just put some words in there to say such and such doesn't apply, and so I think there's ways to do it, and some might use a bit of both, but I think it can be done. And this clarifies the tools available to those Indigenous governments that are working on laws.
Once you have that conflict in your law, then you need to do the coordination agreement process, right? So the way the Act operates is to say that in order for this clear, strong rule to apply, that the Indigenous law will have the force also of federal law, you need to either enter a coordination agreement or you need to spend a year making efforts. So there's like a little process.
There's a process. That's right. It's either you reach the agreement or you've tried to.
So we've touched on this a little, but maybe the last question I want to explore today is what this all means. Like, we've talked a lot about this test and that test and paramountcy and conflicts and a lot of kind of like law inside baseball. But I just wonder what this decision is going to mean for folks on the ground who are either in the process of making their own law or in the process of negotiating a coordination agreement. For those folks, like, what's the thing that they should walk away from this decision with? Jessie, do you have a thought on that?
I mean, I think to start with, the Act remains constitutionally valid, and folks can be following the processes in the Act. And I think as well, I mean, there's certainly solid direction from the court that Canada should be acting diligently to implement these rights and sort of acting quickly and sort of funding appropriately. But I think First Nations can certainly continue their plans to exercise jurisdiction. So this Act remains valid.
Yeah, so it's great, right? And in this way, there's a lot of clarity coming out of this decision that you're kind of, until further notice, good to go. Now, there may be some little challenges here and there at the margins of things, but the main framework and mechanisms of the Act are constitutional. So everybody who's been relying on them can continue their work. And that's, certainty has a lot of value in this context for folks, I think.
Absolutely. And I'd say, people can walk away from this with confidence, right, in their journeys around exercising their own jurisdiction. Sorry, my voice is even scratchier, but I think that's the key message I take away. Those are difficult journeys. Exercising jurisdiction is really hard. And, it's not an easy journey to take responsibility in that way. And to be, to have that authority to decide on the rules and to follow through with them with your own people and deal with these difficult circumstances of families who are really struggling. But for those who are on that path, this gives confidence, to go forward, to continue down that path. And, for those considering it, I think also can give confidence that this is an option. And when people are ready to take those steps, that it is available.
Yeah, and as Jessie points out, this requirement that Canada has, at least, to act diligently is helpful, right? That's a tool that you can use in negotiations. Try and get the arrangements in place quickly and in a way that's adequately funded. Which, there's a lot of difficulties, as Judith says, on this path, and one of them, not just on this path, but in a lot of paths, is making sure that Canada funds adequately the things that it undertakes to do. So there's some resources in this decision to help make those arguments. So that's a positive thing also. So I think we're going to wind it up here. To all of our listeners to this episode of our podcast, we hope you enjoyed this conversation that we had about the new C-92 decision that the Supreme Court put out. And I know there was a lot of information that was sort of conveyed in a short time. And I hope that you were able to learn something new from our conversation. While this topic is fresh in your mind, if you have questions about exercising jurisdiction, if you have questions about how it impacts your own case in the future, feel free to reach out to the lawyers at OKT to speak about how this might actually apply in your own case. I'm Krista Nerland, and on behalf of my co-speakers today, Judith Rae and Jessie Abell, thanks so much for listening to our podcast.